joined by the Honorable Larry M. Boyle, the Honorable Michael H. Williams, the Honorable Ronald E. Bush, the Honorable Terry L. Myers, the Honorable Edward J. Lodge, the Honorable B. Lynn Windmill, and the Honorable N. Randy Smith. All those having business before this honorable court draw nigh and be heard. May God save these United States and this honorable court.
And please remain standing while Chief of the Guard, Patrick Calley, Sergeant with the Ada County Sheriff's Office, will lead the combined law enforcement honor guard in presentation of the colors and also in the national anthem.
Uniformed personnel and military veterans, present HUNT!
Oh, say, can you see by the dawn's early light what so proudly we hailed at the twilight's last gleaming, whose broad stripes and bright stars through the perilous fight o'er the ramparts we watched were so gallantly streaming, and the rocket's red glare, the bombs bursting in air, gave proof through the night that our flag was still there. Oh, say does that star-spangled banner yet wave o'er the land of the free and the home of the brave.
Order, arms!
You may be seated. Well, good afternoon and welcome, everyone. It's my privilege to welcome you to the 225th anniversary, this ceremony and celebration of the passage and signing of the Judiciary Act of 1789, signed September 24 of that year by the first United States Congress and President George Washington. This ceremony is a celebration of that act. Just think of that, 225 years ago. It's not a lot of acts that are living and breathing as long as that one continues to do. The act established the federal judiciary, and the act also, as a result, appointed the first 13 United States Marshals to, among their other enforcement responsibilities, to ensure the protection and safety of the federal judiciary. So really, this is a celebration of the essence of being of both the federal courts and the U.S. Marshal Service. Again, thank you so much for being here. We celebrate today the commitment to the rule of law and principles in the United States Constitution that are at the very core of the Judiciary Act. And along with it, the official oath of office all federal judges and all United States Marshals take, and the service we undertake with the support and assistance of many others to respect and honor that commitment. You will hear more about the Judiciary Act relative to the Marshal Service and the federal courts from our distinguished speakers, the Honorable N. Randy Smith and the Honorable B. Lynn Windmill, in a few moments. But first, I want to head down the path that is always a bit uneasy for MCs, and that is recognizing the number of special guests that we have here today, or what we often call dignitaries. From my view, all of you are special guests and dignitaries, but there are some individuals I'd like to, in essence, call out and thank specifically for taking the time to be here in celebration of the Judiciary Act. Start with, we have United States Senator James Risch and his staff. We have United States Attorney for the District of Idaho, Wendy Olson, and several other assistant U.S. attorneys, including First Assistant Rafael Gonzalez. We also have the Executive Director of the Federal Defender Services of Idaho, Dick Rubin, and other attorneys and staff members from the Federal Community Defender Organization. Many of our friends are here from the Idaho Supreme Court and Idaho Court of Appeals, including Justice Horton and Justice Jones, Judge Grattan, and many others that I'm sure here that I can't put my eyes on at this particular moment. Thank you for being here, along with Steve Kenyon and other staff members. We have with us the Attorney General for the state of Idaho, Lawrence Wasden. Oh, see we go. I believed he was here. But hopefully he'll be joining us. We have Patty Ann Lodge, our Idaho State Senator, and the wife of our own Honorable Ed Lodge. We also have with us Guillermo Orthorica, who is the Consul of Mexico, with staff. Diane Minnick, the Executive Director, the Idaho State Bar. Keely Duke, President of the Idaho Chapter of the Federal Bar Association, and several other members of the Federal Bar Association, the Idaho Chapter. We also have several chiefs of police, prosecutors, public defenders, private practitioners, and many more. And so please accept the thanks from the Board of Judges and the U.S. Marshal Service to each and every one of you for being here and taking the time away from the activities, your busy activities in your daily life, to join this ceremony and this celebration today. And given that the judges and the U.S. Marshals cannot carry out our responsibilities without the dedicated work and service of many others, I'd like to, at this time, provide special recognition to the several members of the Clerk's Office for the U.S. District Court and Bankruptcy Court for the District of Idaho, Chambers staff, and members of our probation and pretrial staff who are here with us today or who are watching the video stream, which is being provided by Idaho Public Television, so that our employees in our divisional offices in Pocatello and Coeur d'Alene are able to partake in this ceremony today as well. We don't have as many probation and pretrial officers here or their staff, and that's because they are in a training program. So undertaking their responsibilities to be trained so that they can carry out their ongoing responsibilities for the court. But as you may or may not know, within the federal system, probation and pretrial services are very much a part of the court, and we appreciate all the work that they do. So I would ask that there be a special recognition for all of the employees and staff of the U.S. District Court and Bankruptcy Court and probation and pretrial services. I also would like us to pause to give special recognition to the U.S. Marshals Service employees and staff, including all of the other U.S. Marshals, in addition to Marshal Brian Underwood, who you'll hear from in a few moments. We have here Chief Deputy Marshal Platts and many, if not all, of the other deputies and many of the staff members of the Idaho's Marshal Service. And we also have members of the Court Security Officers staff. And so I'd like you to provide a round of applause in recognition of the work that these folks do on a daily basis. And now I'd like to turn to recognizing 4 former United States Marshals for the District of Idaho that have been able to join us here today for this special ceremony. First, we have Blaine Skinner. Blaine Skinner is here with his wife, Marilyn. Marshal Skinner was appointed in 1981 and served as the 25th United States Marshal for the District of Idaho from 1981 through 1990. Next, we have Michael Johnson. Marshal Johnson was appointed in 1990 and served as the 27th United States Marshal for the District of Idaho from 1990 to 1994. Next we have James, also known as Jim Benham, and his wife Elizabeth. Marshal Benham was appointed in 1994 and served as the 28th United States Marshal for the District of Idaho from 1994 to 2002. And we have Patrick McDonald and his wife Sarah Jane. Marshal McDonald was appointed in 2002 and served as the 29th United States Marshal for the District of Idaho from 2002 through 2010. And so please join me in a round of applause for these. And now I'm going to introduce the person that is actually most responsible for this ceremony and celebration, and that is our current United States Marshal for the District of Idaho, Marshal Brian T. Underwood. And he's here today with his wife Kim, also joined by his parents, Brian and Lorraine Underwood. And of note, it is Brian and Lorraine's 49th wedding anniversary today. Same day. I can tell you that Marshal Underwood went through a long process of planning and organizing this event, which included quite a bit of give and take, a lot of giving on his part, a lot of taking on his part, a lot of giving on part of the judges, and a lot of taking on part of the judges. But we're all very happy to be here and again to celebrate the essence of our being, our joint being. I do want to recognize, before Marshal Underwood provides comments, some short remarks, that Marshal Underwood was assisted by Susie Headley, our ADR coordinator, and she who does whatever you ask to do for the court, for the District of Idaho, and also by the Ninth Circuit executive staff members David Madden and Alex Clausen, who, along with others, were instrumental in putting together the commemorative booklets that you all received for today's program. Marshall Underwood took the oath of office on May 20th of 2010, beginning his service as the 30th United States Marshal for the District of Idaho, the position he still holds today, and from which he had the genesis for this program, which he's told me is the only one occurring today, jointly with court and marshal service around the country. So it's another example of how in the District of Idaho or in the state of Idaho, we often join forces, whether it's county, state, and federal, marshal, and court. We are all part of the same team that is to support and uphold the rule of law and the Constitution of the United States. Marshall Underwood.
Thank you for being here today. Right before we started, which I got to tell you kind of threw my game out of whack just a little bit, because I practiced my remarks with my daughter who goes to Boise State, and she said, "That's horrible, don't give that, you need to change that." Senator Risch handed me a copy of the Judiciary Act of 1780 he picked up from the National Archives on his way back here to Idaho. And so I'm like, wow, why don't we just pass this around and we'll talk about that and we take care. So Senator, thank you very much. That was very kind of you. In 2008, shortly after my successful re-election to the Pocatello City Council, a man who has known my family for many years engaged me in the following conversation. He said, "Brian, I'm sure grateful for your mom and dad. They're very nice people. Your dad is so nice. He's always smiling. And your mom, she's so involved in the community. By the way, Brian, tell your dad congratulations for being elected to the city council." Now, remember, I was just reelected, and my dad and I share the same name, so this gentleman thought he had voted for my dad. So it's on that theme that I want to just share a few brief remarks with you, the theme of gratitude. He was grateful that he knew my father and grateful for what a good man he was, and that benefited me. And that's probably how the whole city was, quite frankly, because anyway. Because gratitude is a feeling or an attitude of a benefit one has received. I am grateful for the office of United States Marshal and the foundation that it represents to law enforcement today. For law enforcement got its roots or received its roots, I apologize to the attorneys in the room if I don't exactly use appropriate legal language, but the United States Marshal foundation of law enforcement in the country started with George Washington in the first Congress. As a matter of fact, in writing to Edmund Randolph, the first Attorney General, this is what George Washington said in a letter 4 days after he signed the act. He said, "Impressed with the conviction that the due administration of justice is the firmest pillar of good government, I have considered the first arrangements of the judicial department as essential to the happiness of our country and to the stability of its political system. Hence, the selection of the fittest characters to expound the laws and dispense justice has been an invariable object of my anxious concern." The director of the Marshal Service mentioned today that since 1974, the Marshal Service, in partnership with its state and local counterparts, many of our sheriffs and chiefs are here today, have arrested 1.4 million fugitives since 1974 and helping to make our communities safer. And although our duties have varied throughout history, we started at one point taking the national census. We don't do that anymore. And although I know most deputy marshals and marshals that I'm familiar with would probably do anything they were asked to do, quite frankly. But we don't take the census anymore. Today we focus on non-compliant sex offenders, fugitives, witness security, seized assets of criminal organizations, and our main focus of protecting the federal judiciary. I'm grateful for the Office of United States Marshal and what it represents to law enforcement. Number two, I'm grateful for the judiciary, the third branch, the courts. Our founders were very wise to have the President nominate wise men and women, and then to have the Senate advise and consent to these nominations, providing the checks and the balances to the people that should serve in these important offices. Because of the immense power to strike at citizens, not with the mere individual strength, but with all the force of government itself, the post of U.S. Attorney, U.S. Marshal, and federal judges from the very beginning have been safeguarded by presidential appointment requiring the confirmation of the Senate of the United States. So for that, I am grateful. And finally, I am grateful to the honorable men and women who work in the positions behind the scenes, the court staff, the Marshal Service staff, and finally, for those of our family and friends who support us in these very difficult and dangerous assignments. Judge Dale has spent some time acknowledging these individuals and the former marshals who are here with us today, but I too tip my hat and offer my congratulations for this time that we could be together to recognize this historical day. Now let me end with this story. In 1783, at the conclusion of the Revolutionary War, there was an anonymous letter being circulated by some of the American military officers who were bitter about not being paid for their services in the war. The letter suggested a coup where they would take control and make George Washington king. Well, spending some 3 days writing a speech because he knew he needed to talk to these men, it's now known as the Newburgh Address, you can look it up. He met with them and reminded them of the 8 years they had spent together and the things that they had fought and died for. He then remembered that he had a letter with him in his pocket from a Joseph Jones, a congressman from Virginia, who had promised that if they would be patient, they would eventually get the monies owed to them. Many people around George Washington did not know he could not read without his spectacles. He thought it was a sign of weakness, a sign of aging, and so he didn't publicly use his spectacles. But at that time, stumbling over opening the words of the letter, he put on a pair of spectacles and he said this, "Gentlemen, you must pardon me, but I have grown gray in your service and now find myself going blind." This incident was so moving that many officers wept. And in that moment of humility, Washington reminded these soldiers that the first rule of leadership is to serve, not to rule. And the next day, the soldiers passed a unanimous resolution commending General Washington for his devotion and leadership, and the coup was over. So I've thought for many years that George Washington was the father of our country because he was the first president, when in fact he's the father of our country because he had the humility not to be the king. He was a true embodiment of public service. So today, as we take a moment to reflect on 225 years of history, we must ever resolve to be true public servants, to be filled with gratitude, much like the gentleman was that he elected my father to the city council. And I conclude with this quote taken from one of the most famous U.S. Marshals we all know, Tommy Lee Jones. And I've changed the words just a little bit, but this is what he said. He said, "Listen up, ladies and gentlemen." You remember when they were by the side of the train that was wrecked and they were looking for a fugitive. "Listen up, ladies and gentlemen. What I want out of each and every one of you is a commitment that you will be full of gratitude and honor for the people and for the honor it is to work for the people of the United States of America. If you are not filled with this attitude of gratitude, I want you to look in," and this is the quote, "I want you to look in every gas station, residence, warehouse, farmhouse, hen house, outhouse, and doghouse until you find it. Checkpoints on your integrity go up at every important decision in your life. Your fugitive's name is justice, integrity, and service. Now go get him." Thank you.
Before I introduce our first speaker, I do want to make note that we are missing here today only two of our sitting federal judges, Judge Trott and Bankruptcy Judge Pappas. Neither of them could be here due to other conflicts in their schedule, but I know that they very much wanted to be here. So they join in their appreciation for all of you being here and being part of this celebration and this ceremony. But we do have with us as our next speaker of the afternoon, the Honorable N. Randy Smith. who we fondly refer to as our Ninth Circuit Judge from Idaho, who kindly chose his chambers to be in Pocatello and stay with us in Idaho to the majority of time that he can do so. He travels an inordinate amount of time around the circuit and sometimes outside the circuit and outside the country, but he does an amazing job of being part of the Idaho federal judiciary. He also continues his efforts in training the Idaho state judiciary. I believe he was doing some of that yesterday or this week. Again, he exemplifies what I talked about earlier in our ability to join forces, the Idaho and federal courts, and to learn from one another and to support each other to the extent that we can do so. Judge Smith is very good about sharing his wisdom, again, with all of us. Sometimes we're a little concerned about what he's saying, given that it's our decisions that are on appeal that he's commenting about. But he does not hesitate to share his wisdom with us in a very protective way, both the bankruptcy court and the district court. He is truly a marvelous and loyal friend to the judiciary and to all of the people of the state of Idaho. And so, Judge Smith.
Senator Risch, Chief Judge Windmill, Marshall Underwood, Judge Dale, members of the federal and state judiciary, former marshals, members of the Idaho legislature, ladies and gentlemen. Mark Twain said, "Don't clap too much at first, it only encourages them." I'm glad you did that. What an honor to be asked to speak today on the anniversary of the Judiciary Act of 1789. Now, don't get me wrong, I know full well why I'm here. Judge Trott had other commitments, but even as his substitute, I'm still honored. I do solemnly swear that I will faithfully execute the office of the President of the United States and will, to the best of my ability, preserve, protect, and defend the Constitution of the United States. So goes the oath of office outlined in Article 1, Section 1, Paragraph 8 of the Constitution of the United States. That oath serves as a pattern for oaths repeated by each of the officers about whom I am going to speak today. Taking this oath is the process by which one accepts the responsibilities of their office that they are about to enter. Article 1, Section 1 states, "The judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as the Congress may from time to time ordain and establish." As you will remember from your high school government classes, and even if I were to call on Marshall Underwood, I'm sure he would be glad to tell you, there are three branches of government. Article 1 being the legislative branch, Article 2 the executive branch, and Article 3 the judicial branch. The language of Article 3 evidences the problems encountered by those trying to write a new constitution in determining how to build the judiciary of the United States. Other than the Supreme Court, the constitutional writers fought about how strong the independent judiciary should be. The Federalists, of course, seeking a powerful judiciary, including allowing courts of appeals to determine questions of fact from the record. And the Anti-Federalists, they wanted to limit the power of the judiciary. They also fought about how the federal court system should be organized. And therefore, as the language suggests, other than the Supreme Court, they left it to Congress to deal with those very difficult issues. This language gave birth to the Judiciary Act of 1789. And even though we celebrate its birthday today, I'm not going to go through every bit of that act. As Elizabeth Taylor told her fifth husband, I won't keep you here that long. However, I did want to highlight certain provisions of that act, which I think are important to deal with on this day. The Judiciary Act, in fact, organized three different parts of the national government. The first, and I was very happy to see our U.S. Attorney here, the first was the United States Attorney, and therefore, to some extent, the Attorney General, though it was not known exactly whether the Attorney General would have much to do with what they did then. They were charged with the prosecution of all delinquents for the crimes and offenses cognizable under the authority of the United States. Any justice or judge of the United States was second. Any justice of the peace or other magistrate. Though their power was outlined in Article 3, Section 2, they were restrictively given the following power: federal arrest authority. Of course, no one thought the judges would strap on pistols and use handcuffs and take on the rabble and the rousers of America. Can you just imagine our judges doing that? Quite a picture. I'm told they even have a tough time at the firing range. Nonetheless, one could probably see Cowboy Eddie Lodge doing just that. Nonetheless, the judiciary was to issue warrants and judicial process directly to the United States Marshals. With such warrant, the marshal was then empowered to, and I quote, lay hands on the accused and haul them before the court. With this approach, the Congress, like those writing the Constitution, was not putting too much power in any one official's hands, and was again making certain not to allow any of those three delegated officials to become too powerful. My part on this program is to emphasize the importance and the history of the U.S. Marshals, thus organized 225 years ago. I will thus attempt to do that. I hurry to emphasize that I have used some of Frederick Calhoun's book on the history of the U.S. Marshal Service to assist me. Now, when I think of the U.S. Marshal, I'll admit I don't think of Marshall Underwood. He's much too smooth and much too articulate. Who do I think of? I think of Marshall Dillon of Gunsmoke days and his straightforward approach. Though he seemed to be always fair, if you didn't do what he said, always legal, I suppose, as I remember, you were a dead goner. His gun barrel on his pistol was long to signify the long arm of the law. His deputies were more than a bit goofy and were always concerned about less important things. I hurry to say that the deputies of today are not like that. And his girlfriend, Kitty, who ran the Long Branch Saloon, was the best looking woman in town. That's the marshal I remember. I'm not even certain that this marshal was even envisioned by the act, because the act organized the marshals as follows. The marshals were to be appointed by the president, but were to be supervised by the Secretary of State. Why? Because the Attorney General was essentially a part-time job at the time and only included representing the government in court. Marshals had a 4-year term. One with such power should not have more. Marshals could hire deputies as they saw fit, but the deputies would need to quit when the marshal quit. Marshals were essentially given free rein. They were to carry out the duties of the secretary to promulgate laws and proclamations. They were generally to support the court system. They were not given a badge, though I remember Marshal Dillon had one. If they had one, they had to buy their own. No one at that time was designated to carry out the will of the national government, so the marshals were left with that responsibility, and often were the federal government in most places, especially on the frontier at that time. The act outlined that they dispersed the money. Pretty good deal. They got the money. Paid the fees, paid the expenses of the courts, paid the U.S. attorneys, paid the juries, paid the witnesses, rented the courtrooms, took care of the jails, selected the bailiffs, criers, and janitors. They controlled the selection of the juries and grand juries. They distributed presidential proclamations. They served subpoenas, warrants, summonses, and other processes. And from this service, they derived their set fee. And that's how they made their money, was in delivering these. For some, that meant taking the office in hopes they'd get another better paying job soon, because they weren't in a big district court. They collected a variety of statistical information, and as Marshall Underwood has said, they took the census. They supplied the names of government employees for the Federal Register, and if you weren't on the Federal Register, you didn't get paid. They were commissioned to do everything the president wanted them to do. And it has been said, and I quote, "In fact, the president found in marshals a convenient national structure to carry out the administrative functions of the federal government. Appointed by the president, the marshals served at his will and answered to him, while the courts were the marshals' clients, for whom they performed numerous services. It was the president for whom they worked. As such, they enjoyed a wide latitude in determining how they would enforce the law, and at one time or another were called on to do many different things." So how did you become a marshal? Well, you had to be a man in that day. Thank goodness we've changed that. We had to be a veteran of the Revolutionary War. 14 of the first 16 were. You had to be a prominent local figure because they believed that the marshals, and I want to say this because I think it's important, they wanted the marshals to be understood by their people, for they were dealing with their friends and their neighbors. Marshals were not to offend their friends and neighbors, and particularly didn't, because they knew that the job of marshal was temporary. They were fierce, loyal Federalists when we first began. Of course, then Thomas Jefferson was elected president, arch enemy of the Federalists, and he purged all 18 federal marshals on one day, who were fired 1 week after he was elected. They were independently wealthy. Why? Because in order to be a marshal, you had to post a $20,000 bond to protect the United States from your taking the money you were getting as you were going out and doing your work. So law enforcement was not necessary, experience was not necessary. Only 2 of the first marshals had any previous law enforcement experience. So, in all of that, we see what the marshals were. And Catherine DeVry has said, if you travel a path without obstacles, it probably doesn't lead anywhere. And life, of course, is not measured by the breaths we take, but by the moments that take away our breath. And therefore, the marshal service had obstacles and times that took their breath away. 1 or 2 of those, in my short time I have left, I would like to tell you about. In August of 1973, France was engaged in a war with the United Kingdom. The United States courts had to adjudicate prize cases in admiralty from naval battles. So Marshal John Brooks of Massachusetts instructed his deputy to serve a writ of replevin to seize the British schooner Greyhound, which had been captured by a French frigate. Bradford went aboard the Greyhound and said, "I'm here to serve my writ." When confronted by the French Marines, they said, "Too bad, buddy." He said, "Okay, the only option I have that will preserve the dignity of this court, I'll stay aboard your boat and be right here." Well, even the French knew that they might be able to disobey an order, but they couldn't quite kidnap an officer of the United States. So eventually the French frigate took its Marines with it and left the Greyhound. Another time, the Marshals played a critical role in the Whiskey Rebellion. In the backwoods locations in western Pennsylvania, at the time, very edge of the frontier, whiskey was the principal cash crop. As a result, the farmers tarred and feathered a federal tax collector who recognized some of his attackers and swore out warrants against them. Well, guess who was called on? The Marshals. Marshal Fox quickly realized the depth of popular resistance and knew that he was risking his life and limb if he were to serve these writs on these people. Therefore, he hired a cowhand, John Connor, to perform the service. Connor, whipped, tarred, feathered, bound, and left in the woods. Both Fox and he ran. The Marshals at their best. So, as I see what the Marshals are supposed to do, we see that the Marshal Service has had many different responsibilities through the ages. Today, their duties are outlined as our Marshal Underwood has suggested. I suggest that even the duties the Marshals undertake today are filled with obstacles and that their breath is taken away in filling them. As many as 300 marshals and deputy marshals have been killed in the line of duty since the creation of the office. A majority of those deaths occurred in the last half of the 19th century. It can be said that the marshals were generally brave and courageous, but they were usually killed in performing their brave and courageous acts because they didn't have sufficient training, support, and equipment. A lesson for today. The first U.S. Marshal killed was Robert Forsyth, Georgia Marshal. He was attempting to serve civil process on the Allen brothers, a notorious gang in Georgia. In Idaho, 4 marshals have been killed. In 1940, 2 were killed when trying to serve a warrant on a man for contempt of court. 1951, a deputy was killed in an automobile crash while he was on duty. And in 1992, a deputy was killed trying to provide cover for fellow deputies at Ruby Ridge when they were sent to captive a fugitive who failed to appear for court. Now, ladies and gentlemen, Maya Angelou said, "People will forget what you say, people will forget what you did, but people will never forget how you made them feel." The best remembrance you'll get today is to open that book you were given. I hope that you keep that book. Very wonderful book. And on page 7 and 8, it reveals the history of the Marshal Service. On page 14 and 15, it reviews the history of the U.S. Marshals in Idaho. And on pages 31 to 34, it gives a list of the marshals in Idaho. Would all of you who are marshals, former marshals, deputy marshals, or assistant marshals, please stand. for a minute. Today is a special day. We honor the passage of that law, putting in motion the judiciary and the marshal services that we know it today. We can't all be heroes, because some of us have to sit on the curb and clap as the heroes go by. When I was sworn in as a judge, I could hardly believe when somebody told me that the marshal, the court security officer, and the bailiff would be asked to take a bullet for me. I have now seen the Marshal Service and its assistants in action for nearly 20 years. And I pledge to you, ladies and gentlemen, this group does give their lives, their homes, and their sacred fortune for me and the judiciary. As Martin Luther King said, the ultimate measure of a person is not where he stands in moments of comfort and convenience, but where he stands in moments of challenge and controversy. The members of the Marshal Service, you are my heroes. I'm not sitting on the curb, but I now clap, as did everyone here, for you. Thank you for your service for the past 225 years to our country and its citizens. I do solemnly swear that I will faithfully execute my office as United States Marshal and will, to the best of my ability, preserve, protect, and defend the Constitution of the United States. Thank you.
Well, before we turn the podium to Judge Windmill, I want to recognize Attorney General for the state of Idaho, Lawrence Wasden, is here, and also I saw United States Congressman Raul Labrador joining us. So thank you for being here. Brief introduction of Judge Lynn Windmill. Doesn't really need much of an introduction, but to the extent that you want to read more about us in this book, there's detailed biographies about each of the judges. Judge Windmill, perhaps one of the distinctions that I will point out today is he is, I believe, the longest serving chief district judge in the history of the district courts. He was appointed to the district as district judge for the District of Idaho in 1995, following his service on the state court bench in Bannock County. And since 1999, yes, it's coming up for a few more years, Judge Windmill, he has served as the chief district judge for the District of Idaho. He's had a lot of accomplishments. One I do want to point out is that Judge Windmill, along with Judge Bush, while Judge Bush was on the state court bench, Judge Windmill was on the federal court bench, they founded the Idaho Legal History Society. And one reason I wanted to mention that is because the Idaho Legal History Society was very much involved in providing a lot of the history and the materials that are included in the commemorative program. And so our thanks to Judge Windmill and Judge Bush for founding that organization, that society, and I know there are other members of the society here today. With that, we'll hear from Judge Windmill regarding the history of the federal courts.
You know, I've known Judge Smith for 35 years, probably. We've worked together in church settings. And it seems like I'm always having to speak after him, and it's just not fair. I don't know how, you just can't top Judge Smith. I also, before I started, wanted to thank Marshall Underwood for putting this together. He's another Pocatellan, and as you might note, there's a lot of Eastern Idaho folks that serve on the federal court. I also wanted to thank Senator Risch and Congressman Labrador for being here. It means a great deal to us. We serve in different branches of the government, but I think we share the same commitment to the rule of law and the importance of the Constitution and the greatness of our country. And finally, I want to thank specifically our state court colleagues, Justices Jones and Horton and Judge Grattan, and Attorney General Wasden, who's here as well. As you will see from my remarks, I truly believe in federalism and the need for a close relationship between the federal and the state courts. And finally, maybe I'll have to sit down before I get through my opening comments, but the Joint Honor Guard, that was really remarkable. About 2 weeks ago, I happened to find myself in Baltimore, Maryland, and it just happened to be the weekend that marked the 200th anniversary of the attack on Fort McHenry and the penning of the words to the Star-Spangled Banner. And I was moved just as much by their singing it here today as I was being there at Fort McHenry on that day, seeing that original Star-Spangled Banner, 15 stripes, 15 stars, waving over Fort McHenry as a choir sang that song. My remarks today might be described as a tale of three events, okay? The first such event should be obvious to everyone here, and that is September 24th, 1789, and obviously that's why we're here. The second is not quite as obvious, but for those of you who maybe know something about Idaho history, it should pretty quickly resonate, and that's July 3rd, 1890. And the final event is November 27th, 1989. Now that's going to be noticeable only to a fairly small group of people, and we'll discuss that in a moment. But you'll note that all three of these dates are almost exactly 100 years apart, kind of a nice symmetry for, I think, important events in the history of the federal courts in Idaho. Now, we in the federal courts often refer to Article 3 as the source of whatever judicial power we have. But I think that is maybe a bit of an overstatement, because indeed there was really very little discussion during the Constitutional Convention about the makeup of the federal judiciary. In fact, the notes of the Constitutional Convention reveal that there are only two things that the founders were really insistent upon. One is that there had to be a single Supreme Court to resolve national conflicts. Secondly, there had to be lifetime tenure for those judges in the federal judiciary so that they would not be influenced by political pressures. But there was an intense debate to some extent over even whether to have a federal trial court. And indeed, as Judge Smith read the language that actually found its way into Article 3, it only created one Supreme Court and such inferior courts as the Congress may from time to time ordain and establish. Thus, the Constitutional Convention kicked the can down the road in terms of whether to even have a federal trial court. And this debate carried over into the ratification process. As I think Judge Smith alluded to, the opponents to a federal trial court were generally regarded as the anti-federalists, who in fact did not want a strong central government at all. They were concerned that the state trial courts were already providing jury trials. They had proven effective in protecting property rights and would be very adequate to enforce any new federal rights that may be created. But for some of them, the opposition ran deeper. They perceived and were concerned that a federal trial court might cost the citizens the right to a jury trial, which they perceived as being truly a bulwark against tyranny and governmental abuses and the influences of the wealthy. On the other side were the Federalists, and they were distrustful of the state courts. They were afraid that they would be subject to political influences, that many of the judges would be beholden to certain interests, and that local juries could not be trusted. To sell ratification, the Federalists agreed that the right to a federal trial jury or jury trial would be protected and would be included in the forthcoming Bill of Rights, and that the federal courts would indeed be limited and would only have limited jurisdiction. So the Constitution was ratified, but with these understandings. And it was in this contentious atmosphere that the first Congress met in New York City, Federal Hall, April 7th, 1789. By the second day, a draft of the Judiciary Act was circulating. Interestingly enough, Senator Risch, it was Senate Bill number 1, for whatever significance that has. Its principal author was Oliver Ellsworth, a senator from Connecticut. But it was also supported and sponsored in the House by James Madison, our fourth president, who was a member of the House of Representatives from Virginia. Ellsworth was very mindful of this criticism and concern about the role which the loss of a jury might play and how federal courts might in fact usurp the powers and the rights of the individual. He decided to create a stripped-down version of federal trial courts that would be politically acceptable. Thus, the jurisdiction of these new federal courts were indeed limited. The courts had diversity jurisdiction, but surprisingly, no federal question jurisdiction. Thus, through a series of political compromises, we see adopted on September 24, 1789, 225 years ago today, the Judiciary Act. Interestingly, the Judiciary Act was implemented immediately. In fact, President Washington, the very day that he signed the bill into law, proposed to the Senate his entire slate of the federal judiciary, including 6 members of the Supreme Court and district judges for each of the districts created by the bill. And they were indeed approved almost immediately. But I think what is also important to keep in mind is an event that really occurs tomorrow, and that is the 225th anniversary of Congress's passage of the Bill of Rights. And it is interesting to me that they were one day apart and were seen to be created in tandem. And on September 25th, 1789, the day after President Washington signs into law the Judiciary Act of 1789, the Bill of Rights is approved by Congress and submitted to the states for ratification. Thus, we see that James Madison in the House and Senator Ellsworth in the Senate together created this structure, which we have been blessed with over these 225 years, drafting a Bill of Rights which creates the rights which we enjoy as citizens of this country, and authoring the Judiciary Act, which provides a court system in which those liberties and those rights can be vindicated. Let me now move forward 100 years. Over those 100 years, the federal courts grew and evolved upon the framework created by the Act of 1789. And our country grew. The Oregon Country was created. And finally, Idaho became part of the United States after the Oregon Treaty of 1846. In 1863, Idaho became a territory, and we were provided with territorial courts, kind of the predecessors to our state courts. Then on July 1st, 1890, Congress passed the Idaho Statehood Bill, and President Harrison signed that into law on July 3rd, 1890, almost exactly 100 years after the passage of the Judiciary Act of 1789. That date is significant, though, for us here today, not just because it created a state, it also created a district of Idaho. At that time, of course, and we all know what happens when judgeships are created, a confirmation fight immediately ensued. Judge Beatty was ultimately nominated 9 months after the creation of the District of Idaho in March of 1891, but only after overcoming opposition, surprisingly, from the entire Republican congressional delegation, even though he was a Republican, and also the opposition of all of his colleagues on the territorial Supreme Court. Somehow he made it through and he became appointed, or he was appointed. Interestingly, he received his appointment on March 7th, 1891, about 9 months after the district was created. But he began hearing cases immediately and was not confirmed until almost a year later. He began to sit on cases immediately in Pocatello, Boise, Moscow, and Coeur d'Alene, the same venues where we hold court today. And he served as the only judge in Idaho until he retired in March of 1907, when he resigned and retired initially to Coeur d'Alene and later to Hollywood. To me, it is interesting to consider the types of cases which Judge Beatty handled. With the assistance of Emily Quinn, our circuit librarian, I pulled up all of Judge Beatty's opinions on Westlaw. There were 48 reported cases. 12 involved mining law, far more than any other area of the law. The other cases seemed representative of the time: mortgage foreclosures, railroad disputes, labor disputes, disputes over white property ownership on an Indian reservation, water rights, and irrigation disputes. A review of our court records revealed that the criminal cases which Judge Beatty handled were a rather unique mix, far different from the cases we hear today. The cases he tried included the robbing of mail pouches, embezzling stamps and money orders, larceny, murder on an Indian reservation, possession of opium, counterfeiting and receiving cigars from the factory without a tax stamp. Now, that was a new one for me. I can promise you I've never seen that federal crime prosecuted in my court. And Wendy, don't get any ideas. I don't think we need to add. But the most widespread crimes were the selling of alcohol on Indian reservations. Now, as I reviewed Judge Beatty's decisions, I think there were some themes that stood out. I want to go over those very briefly. I think first he saw the rule of law as a means of fostering economic development. And that's something I still believe in today. I think the rule of law is what sets our country apart and makes our economic machinery move. Through the enforcement of contracts and the creation of new rules tailored to the American West regarding water rights and mineral rights, he established a jurisprudence which I think set in motion and then subsequently oiled the gears of our state's economy. He was very sympathetic to immigrants, and at that time it was a very different immigration problem. Congress had passed in 1892 the Chinese Exclusionary Act, which made it virtually impossible for someone from China to become a citizen of the United States. Judge Beatty was sympathetic to their plight and narrowly construed that statute so as to make it easier for Chinese to become citizens of this country. He was sympathetic to the plight of the Native Americans, particularly the Nez Perce tribe. He was hostile to Mormons, as manifested by the numerous cases he handled involving the final few cases involving prosecution of Mormon polygamists. Consistent with the views of the day, he had mixed feelings about the plight of the working man, the working woman, and yes, the working child. He recognized the difficulty, often the tragedy of their situation at the turn of the century. And we see that concern manifested in his written opinions when he sometimes will wax eloquent about that plight. But he also struggled and I think had a difficult time comprehending the inherent weakness of the workers' bargaining position and did not understand or comprehend the need for concerted activity to counter the power of the timber company, the mine owner, and the factory owner. Ultimately, his concern, which I think was vindicated by history, was that labor activity at that time would almost inevitably lead to violence and would disrupt our economy. From this vantage point, he almost invariably sided with management against labor unions. And I want to take just a minute and do a little side trip through history about one of those cases and Judge Beatty's role. In 1892, Judge Beatty convened a special term of court in Coeur d'Alene, Idaho. His goal was to deal with labor violence, which had shut down the mines and resulted in the declaration of martial law and the arrest of hundreds of striking workers. Judge Beatty ultimately enjoined the labor unions from their activities. He sentenced 9 labor organizers for violating the injunction. And finally, in September of 1892, he held criminal conspiracy trials against the labor agitators. That quelled the labor unrest in the Coeur d'Alenes until 1899, when, under the direction of the Western Federation of Miners, a radical labor union, the violence exploded again. A smelter was dynamited. A train was seized by striking workers. I believe 4 individuals were killed in an armed battle that ensued between striking miners and the private army employed by the mine owners. Governor Frank Steunenberg, a Democrat elected with labor support, pleaded with President McKinley to declare martial law and to have the federal troops called out to quell the unrest that occurred in North Idaho. Ultimately, over 1,000 miners were arrested and held for weeks and months in outdoor bullpens. The violence was suppressed, but the anger and the hostility was simmering just below the surface. Governor Steunenberg stepped down the next year. But 6 years later, on December 31st, 1905, as Governor Steunenberg, now I think 5 years removed from being governor, walked back to his home in Caldwell, opened the front gate, and a bomb went off, killing Governor Steunenberg. Many believe with some justification that the governor's assassination was in retaliation for his role in the labor unrest in 1899. A drifter by the name of Harry Orchard was soon arrested, confessed, and told the police that he was acting under orders from Big Bill Haywood, George Pettibone, and Charles Moyers, who were leaders of the Western Federation of Miners. All 3 were living in Colorado, which was the headquarters of the union, but because of some quirks in federal extradition law, these individuals could not be extradited back to Idaho for trial. Taking matters into their own hand, a group of mine owners from northern Idaho, with the probable blessing of the governor and attorney general, but without legal process, hired the Pinkerton Detective Agency to apprehend, kidnap, if you will, the 3 union leaders in Colorado and bring them back to Idaho. The 3 defendants filed habeas petitions in federal court and enter Judge Beatty again into this fray. Judge Beatty was now, I think, less than a year away from retirement, and he was called upon to answer the question of whether or not the state of Idaho had jurisdiction to try these individuals for this murder, where they were brought into the state essentially against their will and without legal process. Judge Beatty decided, yes, the state had that jurisdiction. The matter was appealed to the U.S. Supreme Court, and Judge Beatty's decision was affirmed with only a single dissenting vote. That decision, Pettibone versus Nichols, has never been expressly overruled. And in fact, it was cited just last year by the Second Circuit, which surprised me. And it's also interesting, if any of you know, I guess, our world history, that when Adolf Eichmann was spirited away from Argentina by the Israeli Mossad, taken to Israel to stand trial for genocide and war crimes, the Israeli Supreme Court cited Pettibone versus Nichols, our case, as supporting the actions taken by the Israeli Mossad. Now, I think the story becomes even more interesting, and this is where our state courts, I think, enter into the story in a very significant way. The state at the trial was represented by James H. Hawley, arguably the greatest trial lawyer in Idaho's history, and William E. Bora, later the Lion of Idaho and a member of the U.S. Senate. I think, Senator Risch, you hold his seat, as I recall. The lead defense counsel was none other than Clarence Darrow. The case drew international attention, and indeed the entire world was focused on a trial in Boise, Idaho throughout the summer of 1907. Public sentiment was running strongly against the 3 defendants. Even President Theodore Roosevelt weighed in, describing the defendants as undesirables and making it clear that he thought they should be convicted. The case was tried, though, before a jury of 12 citizens from Ada County. All were or had been farmers. The presiding judge was Fremont Wood, a Republican elected to the bench just the previous fall. And interestingly enough, he had been the first U.S. attorney who had presided and prosecuted those same minors in the 1892 trials which Judge Beatty presided over in 1892. But he had an impeccable reputation for being honest, fair, and even-handed. There was tremendous pressure, I think, on Judge Wood to favor the prosecution, but he refused to buckle and properly, under Idaho law at the time, instructed the jury that the jury could not convict based solely upon Harry Orchard's testimony. There was even greater pressure on the jury. Ada County was clearly not a hotbed of labor activity, and as I said, all 12 were essentially farmers from Ada County. When it came time for the jury to return its verdict, the defense were confident that they had lost. The law was on their side, but the public sentiment was just so powerfully against them that Clarence Darrow, as the jury shuffled in, reached over to Big Bill Haywood and said, "Bill, old man, you'd better prepare yourself for the worst. I'm afraid it is against us, so keep up your nerve." Judge Wood took the verdict form, asked the defendants to stand, and then had the clerk, yes, Jamie, the clerk read the verdict in those days as well. The verdict was not guilty on all counts. Now, I'm not here to suggest the verdict was right or wrong, but what I am here to suggest is that it took the courage of 12 jurors in Ada County and the courage of a state court judge, the courage of their conviction to, I think, tell a story that is important and which should resonate with us here today. You might think it a bit odd that I tell this story on the 225th anniversary of the federal courts. You might suggest that it tells a story of how the federal courts arguably got it wrong in refusing to recognize the impropriety of seizing these 3 individuals and spiriting them off to Idaho. And if there's a hero in this story, I think it is Fremont Wood and 12 jurors in Ada County who followed the law as it was at that time. But if you scratch the surface a bit deeper, it is appropriate for a number of reasons. First, Judge Beatty and the U.S. Supreme Court, I think, did their duty as they saw fit, applying existing precedent to the facts that they had before them. They were not called upon to sanction the kidnapping itself. Rather, they were asked to answer a narrow question. Does the state of Idaho have jurisdiction under these circumstances? While many today, including myself, might question it, I think it is clear that Judge Beatty tried to do his duty. Second, it also highlights a very close relationship, I think, between the federal and state courts in Idaho. Judge Beatty himself had been a territorial judge, essentially a state appellate judge, before he's appointed to the federal court. And most of our judges have served as state court judges. I am no less proud of my 8 years serving as a state court trial judge in Pocatello, Idaho, than I am of the 19 years that I've been on the federal bench. And I'm sure that Judge Lodge feels the same when he compares his 20 years sitting in Caldwell, Canyon County, with the 25 years that he's now served on the federal bench. And I'm quite confident that Judge Bush, Judge Boyle, and Judge Smith, all of whom served on the state court, feel the same way. Finally, I think the story will remind us that the rule of law in America is really a story of federalism, one in which takes all of the players, a state court judge, prosecutor, defense counsel, and juries, as well as their federal counterparts, to get it right. To make our system, our legal system, work in a way that protects our civil liberties, preserves our constitutional rights, and upholds the rule of law, it takes all of us. So let's go forward another 100 years to November 27th, 1989. And I suggest that only a small group of you would know that date. I think Patty Ann might know it. Judge Lodge should know it. On that date, President George H.W. Bush signed the commission of Edward J. Lodge, making him the 10th district judge in the history of the District of Idaho. And I use Judge Lodge to represent our court today because I think he is truly the heart of our court in so many ways. He has more than 50 years' experience as a judge in our state, truly a remarkable record. As I noted, in November, it'll be 25 years that he has served on the federal bench in Idaho, making him without a doubt the longest serving active judge in our state's history. Judge Lodge joined some other great judges, Marion Collister and Hal Ryan, on the district court. At that time, Steve Trott was serving as a circuit judge from Idaho. Mike Williams was our sole magistrate judge. Bud Hagan was served as our bankruptcy judge. Over the next 6 years, Judge T.G. Nelson was appointed to the Ninth Circuit. Larry Boyle became the second magistrate judge in our district, and Jim Pappas was appointed to a new bankruptcy judgeship. 6 years later, my commission was signed by President Bill Clinton. And in succeeding years, President Smith was appointed to fill the vacancy created by the retirement of Judge Nelson. Judge Myers was appointed to replace Judge Hagan, and Judge Dale and Judge Bush were appointed as magistrate judges. Thus, our court has grown considerably since the solo act of Judge Beatty and to the 10 judges who we have sitting as federal judges today. But our work, if anything, has become more complicated and challenging. Our criminal caseload, by comparison to worrying about whether there was a tax stamp on cigars, includes drug prosecutions, bank robberies, child pornography, embezzlement, securities fraud, criminal antitrust, environmental crimes, and immigration cases. But it is in civil cases where I think we as judges leave a mark which is more noticeable to the citizens of our state. Consider with me for just a moment, and I am almost done, these thorny questions which our federal judges have been called upon to decide. Did Idaho have the right to ratify the Equal Rights Amendment and then rescind its ratification? What happened on Ruby Ridge, where a United States Marshal and 2 members of Randy Weaver's family were killed? Are the mining companies who contaminated Lake Coeur d'Alene liable for its cleanup? Should the court uphold Idaho's roadless rule that was carefully crafted through difficult compromise between industry and conservation groups under the direction of then Governor Jim Risch? How can the bankruptcy code be administered in hundreds, if not thousands, of agribusiness and corporate reorganizations so as to balance the interests of creditors with the need to foster the lifeblood of our state's economy? What protection does the law provide for endangered or threatened animals and plant species? Does the First Amendment protect expressive conduct like nude dancing? Does it protect the surreptitious filming of activities in feedlots and dairy operations? What sentence should be imposed on individuals who have no criminal history, a lifetime of community service, but who have been convicted of financial fraud involving hundreds of millions of dollars? Does the state's largest hospital violate federal antitrust laws in acquiring large physician practice groups? Does the right to bear arms have any limitation on property operated by the Army Corps of Engineers? Does the state's ban on gay marriage violate the equal protection or the due process clauses of the 5th and 14th Amendments? How far can the state go in restricting abortions? Who owns Lake Coeur d'Alene, the state of Idaho or the Coeur d'Alene tribe? Now, these, I hope you will understand, are difficult, thorny, challenging questions. And I pose them as questions, not as answers pronounced from on high, because I'm not sure even all of the judges on this dais would agree with the decisions that we as individual judges have rendered in these cases. But I hope that all of us will agree that the judges assigned to those cases trying to write decisions which answer those difficult questions have always done their best, have always strived to uphold the rule of law, have always endeavored to approach their jobs with both thoughtfulness and restraint. In closing, I hope that I've given you a sense of the importance of the Judiciary Act of 1789 here in Idaho, and how the framework which it established 225 years ago has been put to work in not only protecting our constitutional rights and civil liberties, but also in helping us resolve some of the most challenging, difficult, and vexatious problems facing our country and our state today. So I'd leave you with a question to ponder. What will others say in another 100 years about how we have discharged our duty to safeguard our legal system, preserve the rule of law, and protect our civil rights and liberties? It is not a question just for the judges, both state and federal, in this room. It is also a question for every citizen of this great state. I sincerely hope that our children and our children's children will look back and conclude that we have earned the trust and confidence bestowed upon us by Oliver Ellsworth and James Madison and President Washington as they adopted and signed the Judiciary Act of 1789, that we have followed the great example of Judge Beatty, Judge Wood, and the 12 jurors who sat on the Steunenberg murder trial, that we have shown an equal commitment to the rule of law and the civil rights and liberties of our fellow citizens. Thank you.
Thank you, Judge Winnell. I failed to recognize our court unit executive, which I prefer to call clerk, Liz Smith, for being here, who called court, and also our court reporter, Lisa, who's been taking down this proceeding. So my thanks to them as well. Marshall Underwood, you asked, this was in your, I'm not sure, your giving of guidance, that you wanted this ceremony to be serious, fun, and inspirational. I think you met that criteria. With that, ladies and gentlemen, I'd like you to join us for a ceremony, or after the ceremony, for a reception. I think it's the room directly behind us. It's a reception that is sponsored by the Federal Bar Association Idaho chapter, and our thanks to the Idaho chapter for sponsoring that. Is there any further business to come before the court? With that, then, court's adjourned.
All rise.